So that judgment is basically the complete and detailed decision of the judge, and he will state all the facts, all the proceedings, all the arguments, all the observation of the judge, observation of the parties, witnesses' statement, expert opinions, documentary evidence, real evidence, circumstantial evidence, whatever has been adjudged, whatever has been observed during all the proceedings, such and such things will be incorporated in the judgment. After the judgment, uh, there will be idle conviction, there will be either conviction or acquittal. If the court deems fit that there is no proper evidence is there, and we are not in a position to punish the wrongdoer, keeping in view the lackness or the credibility of evidence or the uh, other mitigating circumstances, the court will not award the punishment or him. The court will acquit it. But if there is a tangible evidence, there is credible information and irrebuttable evidences are there, which categorically incriminate the accused, that by all probabilities he has committed uh, this offense, and all the evidences, all the direct evidence, indirect evidence, with corroboration, then he will be convicted. So I have narrated few terms like corroboration. Corroboration is basically those supporting evidences which strengthen the evidence, which cement it, which cement the evidence, which gives evidence authenticity, which gives the evidence credibility, which gives the evidence authority. The judge always look for corroboration. Corroboration, you can say, is the mandatory requirement. Evidence is may not be accepted without any corroboration. There is an equal chance of exploitation, manipulation, and distortion of facts. So, in criminal law, let me tell you one thing: the accused is the favorite child of law. In criminal law, the accused is the favorite child of law, which means that if 99.9 things, 9% things are against him, and if there is a slightest doubt regarding his involvement, if there is a slightest doubt, 1 point doubt is in his favor, and 99.99% facts, circumstances, evidences are against him, then he will not be given death punishment, because in criminal law a lawyer of defense has to create a shadow of doubt. Even a shadow of doubt will save the accused from the death punishment. So this is a tip for you. You guys are about to enter into this legal field. Your career is just waiting for you. Only few months away, you will be entering into the field of legal profession. Remember one thing: a smart lawyer always works smartly. In criminal cases, the prosecution has to prove its case beyond the shadow of doubt. Beyond the shadow of doubt. What does it mean? Okay, if they are unable to prove their case, and even a shadow of doubt is there, remains there, then the defense will be acquitted. The punishment of death will not be awarded. So in criminal cases, it is very easy to save the skin of the criminal. But you just have to create A shadow of doubt. You know, there is another saying that uh, it is better to save one innocent person than to kill 900. I don't know the exact figure. Supposedly 900 criminals. To kill 900 criminals, it is much better or much superior to save, excuse me, one innocent person. So this is the beauty of the criminal law. Uh, Read the case carefully, read the files, read the brief, read the stances and narrative of both the sides, read the statements of the witnesses, read the FIR, read the investigation report, read the challan, read the finding of the cross examination, examination in chief, and re examination. There will be a discrepancy which will give you a help to create the shadow of doubt or to impeach the credit of the witnesses, of the prosecution or the defense, as the case may be. So things are there. A lawyer's job is to read extensively, exhaustively. You know, the job of the lawyer never sleeps. He has to prepare his case on each and every day. He has to learn each and every day. He has to find out authorities each and every day. He has to, you know, he has to build his case each and every day. He has to work hard. He has to be a jack of all trade. In other words, he must know how to tackle the patwaris. He must know how to tackle the criminals. He must know how to tackle the reader of the judge. He must know how to tackle the hardened criminals. He must know how to tackle the police. He must know how to tackle the doctor's report, because in criminal cases the report of the doctor is very pivotal, very pivotal. So he must be a legal expert, he must be a medical legal expert, he must be a police expert, he must be a revenue expert, he must be a you know expert of everything. Only then, and only then, a lawyer can make a difference. And if you reach at that level, and if you reach at that pedestal, then there will be a, then sky will be the limit. There are many lawyers. You can count on fingertips the prominent lawyers in Pakistan. Atazaz Hassan, right? Asam Zafar, Ijaz Batalvi, right? Uh, in recent days, Hamad Khan, right? Uh, Ahmed Bilal Sufi, right? Or few names will be there. Only few. So 10 to 15 lawyers are those lawyers which are which on them there are consensus that they are the big guns. Why there is a consensus? Because they have burned the midnight oil. They have worked so hard. There is no shortcut of success in practice, especially. The price is very high. You have to read and read and read. So, my dear students, I have told you civil procedure, criminal procedure, civil law, criminal law, civil administration of justice, criminal administration of justice itself, legal rights, and why administration of justice is needed. In coming sitting a short while, after a short while, I will tell you the theories of the punishment, inshallah. And in this theory of punishment, we will find out which theory of punishment is more effective in recent days. So, see you in a while.